Hello, this is James Imvilon, and you are watching Wiser Pinoy TV. For today, we will be discussing about the fundamentals of criminal procedure. Now, when we talk about criminal procedure, we are referring to the process of treating of the series of processes by which criminal laws are enforced and by which the state prosecutes persons who violate penal laws. It also pertains to laying down the processes by which an offender is made to answer for the violation of criminal laws, as distinguished from criminal law, which defines and prescribes penalties. Criminal procedure also regulates the steps by which one who committed a crime is to be punished. Now, let us discuss about the systems of criminal procedure. We have inquisitorial, and the second one is adversarial or accusatory. Now, when we talk about inquisitorial, the court plays vital role and not limited to evidence presented only. The court also has active participation in gathering evidence, and court may utilize evidence gathered from outside. However, when we talk about adversarial or accusatory criminal procedure system, it is a two-sided structure, the prosecution and the defense, and each side presents evidence and convinces the court of its position. The court cannot consider evidence not presented, and this is the system adopted in our jurisdiction in the Philippines. How rules on criminal procedure interpreted? Liberally, in order to promote their objective of securing a just, speedy, and inexpensive disposition of every action. It must be viewed as tools to facilitate the attainment of justice, such that any rigid and strict application thereof, which results in technicality tending to frustrate substantial justice, must always be avoided. Thus, in a case, the Supreme Court relaxed the rules when the accused resorted to an erroneous mode of appeal. In some cases, late appeals were considered. So in another case, the court allowed exhibit not offered when the exhibit formed part of the records. So generally, laws shall have no retroactive effect as pertained by Article 4 of the new Civil Code. So this is expressed in the legal maxim, ex precipit non respisit. The law looks forward and not backward. The general rule, however, that statutes are prospective and not retroactive does not ordinarily apply to procedural laws. The retroactive nature of procedural rules applies to actions pending and unresolved at the time of their passage. So as an exception, procedural rules have retroactive application when favorable to the accused. So that is how the rules are being construed or interpreted. So let us now proceed to due process, the requisites, a law that hears before it condemns. So that is actually a maxim that is associated all the time with due process. Now, when we talk about due process, there are four requisites here. One, that a court hearing the case must be properly clothed with judicial power to hear and determine the matter before it. Second, that the court shall lawfully acquire jurisdiction over the person of the accused. Third, that the accused should be given opportunity to be heard. And lastly, that judgment is rendered only upon lawful hearing. So before a court can exercise criminal jurisdiction, it must have the following. 1. Jurisdiction over the subject matter. So authority to hear and decide a particular offense. And jurisdiction over the territory by which the accused must be tried in the place where any of the essential ingredients of the offense was committed. And jurisdiction over the person of the accused must be brought to the authority of the court by valid arrest or voluntary surrender. So, by saying valid arrest here, it pertains to one with warrant, arrest with warrant, and the second one is those pertains under the rules of court, which are the valid warrantless arrests, such as in flagrante delicto, the hot pursuit, and those who escaped from the prisons. Criminal jurisdiction over the subject matter is the power to hear and determine cases of general class to whom the proceedings in question belongs. So it is conferred by law. So it is important for us to take note that it is conferred by law and not by rules. Courts are without common law jurisdiction, but only those expressed conferred by the Constitution and the statutes in the country. Jurisdiction cannot be fixed by the will of the parties, nor can it be acquired or dismissed by an act of the parties. So in criminal procedure, it's different because in criminal procedure, jurisdiction and venue are considered as distinct concepts, unlike in the civil procedure, wherein venue and jurisdiction may mean the same thing. So jurisdiction over the subject matter is conferred by law as we have learned it in our criminal procedure, while jurisdiction over the case is determined by the allegations in the complaint or information. That is why it is very vital that the complaint and information must be sufficient, wherein it has the capacity to determine the jurisdiction over the case. Okay, it should be substantial enough. Hence, in order to determine the jurisdiction of court in criminal case, the complaint or information must be examined for the purpose of ascertaining, one, whether or not the facts set out therein and the punishment provided for by law for such acts fall within the jurisdiction of the court which the criminal case is filed. Jurisdiction to try a criminal action is determined by the law in force at the time of the institution of the action and not during the arraignment of the accused. It is also settled that the law in force at the time of the commencement of the action determines the jurisdiction of the court over the subject matter and not at the time of its commission, even if the penalty that may be imposed at the time of its commission is less and does not fall under the court's jurisdiction. So it's very important to understand that. In determining whether the court has jurisdiction over the subject matter, the imposable penalty, not the actual penalty, imposed after the trial shall be considered. So here, you will be able to determine which one requires a preliminary investigation, which one is to be filed in the municipal trial court, and which one will be filed to the regional trial court. So as we all know, general rule that if a particular offense is charged with an imposable penalty below 6 years, it shall be filed to the municipal trial court. And if it has an imposable penalty of more than 6 years, then such offense shall be filed before the regional trial court. Okay? So, as we all know also that a case or a particular action filed which has an imposable penalty of 4 years, 2 months, and 1 day, it generally requires preliminary investigation to be conducted by the prosecutor. Okay. But you have to take note that the extent of the penalty which the law imposes for the offense on the basis of facts alleged in the information is also very important to be considered. In cases affected by Republic Act 1095-1, which was approved on August 29, 2017, it is an act adjusting the amount of value of property and damage on which a penalty is based on the fines imposed under the revised penal code, amending the purpose of Act number 3815 or the revised penal code. So upon its effectivity, the municipal trial court has jurisdiction in the crime of theft where the value of things stolen is not more than 1.4 million pesos. All cases that have not been reached arraignment stage are transferred now to MTC. So offenses shall be tried in the geographical limits of the territory over which the court presides. So the action shall be instituted and tried in the court of the municipality or territory wherein the offense was committed or wherein any one of the essential ingredients thereof took place. The exception of this rule is the extraterritorial jurisdiction under Article 2 of the Revised Penal Code, which means these are actions committed outside the Philippine territory or geographical area. The venue in criminal actions is jurisdictional, which means it cannot be stipulated. However, the guidelines for the conduct of pre-trial conference allows parties to stipulate on territorial jurisdiction of the case. Now let us ask how jurisdiction over the person must be or will be acquired by the court. One, as what I have early stated, by lawful arrest or apprehension of the accused with or without warrant. So it should be valid. So I already explained it earlier that there are arrests which are valid even if these arrests have no warrant, such as in flagranto delicti, hot pursuit, and those who escape from prison. And the second one is by his voluntary appearance or submission to the jurisdiction of court. Both are the modes wherein the court acquires jurisdiction over the person. So examples of voluntary appearance or submission is 1. Filing of a motion to quash. So if an accused files a motion to quash, it is inferred and it is understood in the language of law that such person voluntarily appears and submits himself before the court. Thus, the court acquires jurisdiction over the person. Second, appearing for arraignment. If the accused appears during the arraignment, then that also can be understood that the person is voluntarily appearing and submitting himself before the court. Thus, the court acquires jurisdiction over the person. Giving of bail. As we all know that a bail could be a matter of right and a matter of privilege. It becomes, right to bail becomes a right if an imposable penalty of the action filed against him is punishable below reclusion perpetua. However, if such offense is punishable by reclusion perpetua, the person or the accused could still avail the bail under the privilege of the court, given that the pieces of evidence presented by far are too weak or not that strong in order for the court to grant a privilege of bail to the accused. Okay. And lastly, by participating in the trial is automatically understood that the accused is voluntarily appearing and submitting himself before the court. Thus, the court acquires the jurisdiction over the person of the accused. When voluntary appearance not deemed submission to jurisdiction. So we already explained and presented to you how a person voluntarily appears and submits himself in the court. However, there are appearances and submission which are not considered as voluntary or deemed as submission. The rule is that the act of the accused in seeking affirmative relief before the court constitutes voluntary submission to the jurisdiction of the court. So the exception to this is when accused files 1. Motion to quash based on lack of jurisdiction. So if an accused will file a motion to quash on the ground that the court lacks jurisdiction, then it cannot be considered as a voluntary appearance before the court. Second, if the accused files a motion to quash warrant of arrest on the ground that it was unlawfully issued, cannot be considered as a voluntary appearance by the accused before the court. Thus, in these two scenarios that I have presented, the court did not acquire the jurisdiction over the person of the accused. You have to take note also that this is similar to pleading ex abundante ad cautelam, which means out of abundance of caution in civil actions. In custody of law, let us distinguish from being under court jurisdiction. So a person who is arrested or apprehended is deemed taken into the custody of the law. But one can be under the custody of the law but not yet subject to the jurisdiction of the court, such as when accused filed a motion to quash the warrant on the ground that the issuance of the warrant is invalid. On the other hand, one can be subject to the jurisdiction of the court but not in custody of the law, such as when accused escapes during trial. Thus, custody of law is equal to custody of the body, signifying restraint or deprivation of liberty. In the prohibition against injunctions in criminal prosecution, there are certain exemptions under this rule. The rule states that the court will not issue writs of prohibition or injunction to enjoin or restrain criminal prosecution. However, under its exemption, only in extreme cases such as when necessary, 1. Afford adequate constitutional rights of the accused, 2. Orderly administration of justice, avoid oppression, multiplicity of suit, 3. Prejudicial question, which is sub judice, 4th, acts of officer are without or in excess of authority, 5. Accused prosecuted under an invalid law, ordinance, or regulation, 6. Double jeopardy is apparent, 7th, court has no jurisdiction over the offense charged, 8. In a case of persecution rather than prosecution, 9. Charge is manifestly false, motivated by lust or vengeance, and 10. Lack of prima facie case. Let's proceed to mandamus to compel prosecution. The rule: generally, public prosecutors are afforded wide latitude of discretion in the conduct of preliminary investigation. So as a review, I already mentioned when there will be a mandatory conduct of preliminary investigation if the offense charge is punishable above 4 years, 2 months, and 1 day. Exemption, in other words, mandamus does not lie to compel him to prosecute. But there are exemptions to that when the prosecutor committed grave abuse of discretion, as when 1. Despite sufficiency of evidence, he refuses to prosecute, and 2. When the Department of Justice Secretary completely ignores an investigating prosecutor's finding of sufficiency of evidence, and 3. Utter disregard of a finding of probable cause. So, those are the things that we need to know under the fundamental principles of criminal procedure. Let us see in my next episode. Take care and God bless. Thank you for watching.